Hello and welcome to Topic 8, Lecture 1. And in this lecture, we are going to be looking at the organization of the federal courts. So what are we going to be covering in this lecture? Well, first we're going to take a look at the role of the judiciary in American government. What role does the judiciary play in relationship to the other branches of government? Then we're going to take a look at the types of cases and the types of law that courts hear. And so we'll be talking about the difference between a civil law and criminal law, and that difference in law makes up the difference between civil cases and criminal cases. Then we're also going to take a look at the types of courts that we have in the American judicial system. We'll take a look at the difference between a trial court, an appellate court, and a Supreme Court. And then we'll finish off this lecture by taking a look at the organization of the American judiciary. In other words, how is the court system in the United States organized? So let's get started. Okay, so up to this point in the semester, you've learned about two of the three branches of American government. That you've obviously learned about Congress, and that you know that the main function of Congress is to pass laws. They do other things. They have oversight of the other branches of government, but its main job is to pass laws. Last week you learned about the presidency, and we know that the presidency, in conjunction with the federal bureaucracy, that their main job is to execute laws. And so once those laws are passed, then it's up to the executive branch to actually put those laws into action, to implement those laws. And so what does the courts do? What do the courts do as the third branch of American government? Well, the main thing that the court does is that it applies the law. And there are different features of applying the law. One thing that the courts do is that they interpret the meaning of law. That sometimes there might be confusions or misunderstandings about what a law means. And so one thing that the court does is that it, tries to clarify the meaning of law. Another thing that the court does is that it settles the disputes that arise over a particular law. And we'll be using some concrete examples of settling disputes on the next slide. And then another thing that the court does is, in making its decisions about applying the law, that oftentimes it applies the law in accordance with the decisions that the courts have made in the past. And so past decisions of the court are known as precedent. And so that when a court is trying to either interpret the meaning of the law or settle the dispute that has arisen about the law or over the law, one of the things courts will do is they'll say, how have courts ruled in this in the past? And then we'll look at that past decision and we'll use it to drive our decision making today with the case that is presented before us. That is known as stare decisis. And what stare decisis means literally is let the decision stand. And so that when applying the law, oftentimes the court exercises stare decisis, and it basically says that we're looking at how we ruled in the past, and that's how we're going to rule right now on the case that is before us. Let's take a look at a concrete example of interpreting the meaning of law, settling disputes over the law, and then also how courts use past decisions, precedent, to decide cases. And the example we're going to take a look at is the Establishment Clause from the First Amendment. And so, as you know, in the Establishment Clause reads, Congress shall make no law respecting an establishment of religion. Well, one thing courts do, and in this case, we're talking about the Supreme Court because it's their job to interpret, to at least give the final interpretation of the Bill of Rights, the Constitution. One thing that the Supreme Court will do is that they will try to interpret the meaning of the establishment of religion. Does the establishment of religion, does it literally mean that Congress can't make laws that actually establish a national church? Or does it have a broader meaning than that? Does it mean that Congress cannot make laws endorsing or favoring a church, even though they're not establishing a national religion? We know the answer to that. The Supreme Court has provided a broad interpretation of the meaning of the Establishment Clause. It's not just narrowly defined as establishing a national religion. Sticking with the example of the Establishment Clause, do disputes arise over the law? Absolutely they do. Some of the disputes we read in the textbook earlier this semester about disputes over the establishment of religion is whether or not school prayer, or whether or not placing the Ten Commandments outside of the principal's office, whether or not that constitutes a violation of the Establishment Clause. Does that if you have a law that says you have to pray in a public school at the start of the day, or a law that's basically saying that all principals must put the Ten Commandments outside their door, the court has said yes, indeed, that that is doing that violates the Establishment Clause. And so they just settle a dispute over the law. Hey, it doesn't violate the Establishment Clause. No, it does violate the Establishment Clause. And then the court will settle that dispute. And then they'll look to past cases, right? And so when it comes to prayer in school, there was a case you read about earlier in the semester about student-led prayer at a football game at a public school. And they found that was a violation of the Establishment Clause. And the way that they did that is they looked at the way the court had ruled prior on issues of school prayer. And so that's a concrete example of the role and the function that the judiciary plays in American government. Okay, so let's move on now to talk about the different types of laws that your textbook talks about, the difference between criminal law and civil law. Let's start with criminal law first. So criminal law is the kind of law that defines conduct that is not allowed, that it tells us what kind of conduct is prohibited. And so, when you look at criminal statutory law, right, or federal criminal code, it basically is saying that if you engage in this conduct, you have committed a crime, okay? And that there will be a penalty, a punishment for engaging in this prohibited behavior or criminalized behavior. So just some examples of sexual assault. And so that if you touch somebody in a sexual manner without their consent, that is a crime, sexual assault. And there's different grades of sexual assault, from a misdemeanor to, a top level felony. Burglary, entering into somebody's house without their permission and stealing things from them, that's a crime, right? Murder, etc. So all of those are behavior that the state has identified as maybe harmful behavior or immoral behavior, right? And they're basically saying, if you engage in that behavior, you have committed a crime. Now, one thing to keep in mind about criminal law is that the dispute in criminal law is between the state and the individual. Now, there could be a dispute over the meaning of criminal state statutes or federal criminal code, but mostly it's a dispute between that the state is saying that you as an individual violated state criminal law, and that they think that you're guilty, and then the individual says, no, you've charged me wrongly. I have not engaged in this prohibited behavior. And so what the court does is they settle that dispute between the state and the individual. So all criminal cases have Wisconsin versus somebody, an individual, okay? It's not individual v. individual, but it's the state of Wisconsin versus Bob Smith, who's being charged with first-degree intentional homicide or something like that. So it's state versus individual. That's who the dispute is between. And the standard that's used to settle the dispute is really high. The evidentiary standard is beyond a reasonable doubt. So the state must prove beyond a reasonable doubt that the individual charged with the crime is guilty, okay? And the reason the evidentiary standard is so high is because really bad things can happen to an individual who is found guilty of committing a crime. Anywhere from home confinement to probation to all the way up to the death penalty. So that's why there is a higher evidentiary standard, because you want there to be a pretty significant burden placed on the state to prove that in fact this individual engaged in a crime. Key cornerstone of democracy. A civil law is different. A civil law is not a dispute between the state and the individual, but civil law settles disputes between individuals or between an individual and an organization, like a corporation or something like that, or a business, okay? And so some examples of civil law are, let's say that you sign a contract with another person, whether that's a contract, let's say that, you contract somebody to landscape your yard, and you say, I want you to put in a tree and some grass and a bush, and they say, okay, I'll do that, but you have to pay me this amount. And then let's say one of the two parties doesn't hold up at their end of the contract. That would be a breach of contract potentially, and the court would determine who the responsible party was in that suit. Civil law, there's no criminal penalty. And so if you're found guilty of a crime, there's a criminal penalty. You can be incarcerated. You could be put to death. In civil law, there is no criminal penalty, but rather there's compensatory damage. So that if there's damage that comes from you not from you breaching the contract, then the individual who's found responsible, not guilty, but responsible, will say, hey, you've got to compensate for that damage that you've done. And so you need to pay the other individual for the damage associated with, in this case, breach of contract. The evidentiary standard in civil law is much lower. It is that you look at all of the evidence, the preponderance of the evidence, and based on the preponderance of the evidence, is there enough confidence that based on that evidence that this person is in fact responsible? So it's easier to find somebody responsible for breaching a contract because the evidentiary standard is lower, and that's because the penalty associated with being the responsible party is financial, which is hard. That's hard, but it's nowhere near as hard as having your actual liberty taken away. Okay, so here's an opportunity to apply what you just learned about the difference between civil and criminal law. So when you look at these, ask yourself, do you think this is primarily a civil matter, a case dealing with civil law, or do you think that it's a case that is dealing primarily with criminal law? What about the first case is determining child custody. So let's say that you are involved in a divorce, and that after the divorce, that the court is trying to determine who should get custody of the child. Is that a criminal matter or is that a civil matter? Well, if you said civil, you are right. And so marriage is it's a contract between you and another person, and that when that contract is dissolved, then that you have to determine who is going to be the custodial parent, and that the court will determine whether or not there will be shared custody or whether or not one person will get custody over the other. If you lose custody of your child, you're not going to jail. Now, if you are abusing your child, engaging in some sort of criminal mistreatment of your child, not feeding them, beating them, then that's a crime. But just losing custody of your child is a civil matter. It is not a criminal matter. What about failure to pay rent? And so let's say that you just don't pay your rent 1 month or a couple of months in a row. Can you go to jail for that? Is that a crime? It is not. It's civil. Again, it's a breach of contract. You make a contract with your landlord to pay a certain amount of rent, and if you fail to pay that rent, it could be a breach of contract, or the landlord could be breaching the contract because they're not giving you a decent place to live, that the heat's not on, there are rats everywhere, whatever, right? And then you say, I'm not going to pay rent because the landlord is falling down on their side of the contract, right? Not living up to their side of the contract. And then the court would settle that dispute. What about hunting a federally protected wildlife? So let's say you go hunting and you see a bald eagle and you're like, ooh, I'd really like that bald eagle in my house. And let's say you hunt it and trap it and then keep it in your backyard. Is that a civil offense or is that a criminal offense? Well, that is a criminal offense. Certain animals in the United States are protected by federal wildlife laws, and that there's actually a whole branch within the within the federal government that investigates trafficking in protected wildlife, and it's a pretty significant penalty if you are caught, criminal penalty. How about willful failure to pay child support? So what if you owe child support and you fail to pay it? It seems like that would be a civil offense, but in the 1990s, it became a criminal offense in order to strongly encourage people to pay child support. They made it a federal crime, if you failed to pay child support. It's a misdemeanor, and you have to demonstrate that somebody is willfully not paying, but it's a crime nonetheless. How about copyright violation? How about that there's a song and that you make bootleg copies of a song or an album and then you distribute those. Is that a criminal offense or is that a civil offense? Well, it could actually be both. Copyright violation is a criminal offense. However, if you're violating the copyrights of a band by making bootleg copies and selling those, the band could sue you for stealing their intellectual or musical property rights. Okay, and so that is an example of both. All right, let's move on to talk about the organization of the American system of justice, the American judiciary system. And that, how it's organized, how the American judiciary system is organized is a reflection of some key principles within American government. And so one key principle is what is known as federal supremacy. That in the Article 6, Section 2 of the United States Constitution, it's known as the Supremacy Clause. And it basically tells us that the federal law is the supreme law of the land, okay? And so if there's ever a conflict between federal law and state law, federal law trumps state law. So a good example of that is marijuana, we have marijuana is a controlled substance. That means that distribution and production of marijuana is a federal crime. However, a lot of states have legalized marijuana. And so if the federal government wanted to come in, if the DEA wanted to come in and crack down on a state that has legalized marijuana, they could do it due to the Supremacy Clause. But the federal government kind of takes a backseat to that. They basically say, you know what? If you're not trafficking in drugs and sending it either across international borders down into Mexico or up into Canada, or if you're not trafficking between states, we're just going to leave you alone, okay? But if they wanted to, federal supremacy. So keep that in mind when we're talking about how the court is organized. Another aspect of how the United States judiciary is organized is that it's a reflection of federalism. As we know that there are certain powers that are granted to the federal government and there are certain powers that are granted exclusively to the states. And so we see that reflected in the way the court system is organized. In particular, because of the 10th Amendment, police power is reserved for the states. And so, and as a reminder, the police power is basically saying that states are the ones who get to have control over the behavior of the people that live in their states. And so the vast majority of criminal law is handled at the state level. If you commit a murder, chances are you violated state law. If you burglarize somebody's home, you violated state law, not federal law. And so because of that, the state courts are really the workhorse of the way that our system of justice is organized, due in large part to the fact that, because of the 10th Amendment, the states and the police power, they're the ones who handle the vast majority of criminal cases. And so both the federal supremacy and federalism, in particular the 10th Amendment, that these two principles really are reflected in the way that the United States court system is organized. Okay, so let's take a look at the way the judiciary system in the United States is organized. And then we're going to go into some more details about the different types of courts, and then we'll go back and look at this chart again. So this first look at the chart is just an overview. Then we'll go into more detail in a little bit. All right, so like one thing you will notice here is that there are two separate court systems, okay? On this side, this is the federal court system. And so that if somebody violates a federal criminal code, commits a federal crime, they're going to be tried on this level. Also, that if there are civil cases between like states or individuals who live in different states, that is going to be adjudicated on the federal level. On the other side, if you break a criminal law, if you commit a crime in your state, you are not going to be tried in the federal system. You're going to be tried in the state system. Okay. And that also, if you're suing somebody that lives in your state, that civil suit is going to take place at the state level. Okay. So right off the bat, if it's a federal issue, that it's dealt on this side. If it's a state issue, it's dealt on this side. However, right here, and again, that's a reflection of federalism. Right here at the very top of the federal court system, or the court system in the United States, is the Supreme Court of the United States. And that's a reflection of federal supremacy. If there is a question that deals with the federal Constitution, for example, that in the civil liberties section, we learned about the right to privacy, right? And the right to privacy gives a person a right to have an abortion before viability up until the 24th week. Well, this term, we're seeing some cases in the Supreme Court that are looking at state laws that say you can't get an abortion after 15 weeks, right? And recently in Texas, Supreme Court hasn't agreed to hear this case yet, but they say you can't get an abortion until after 6 weeks. Well, that's a federal question because it deals with the constitutionally protected right to privacy. And so while those cases might work their ways up through either the federal side or the state side, for the final last sort of say on whether or not those kinds of state laws violate the U.S. Constitution, that is going to be heard by the Supreme Court of the United States because of federal supremacy. And they have the final say when it comes to federal issues, in particular, the final say when it comes to the Constitution. So now let's take a look at like what these different, the different types of courts, because we see here trial courts and U.S. district courts are trial courts. You see the U.S. Court of Appeals and the state appellate court. Let's talk about the difference between state or trial courts, appellate courts, and Supreme Courts. Okay, so let's look at the different types of courts that are present within the American judicial system. And these types of courts are present on the federal side, and they're also present on the state side as well. The first court, and this is the court that was on the lowest level of the chart, and we'll look at that chart again in a moment, are what are known as trial courts, okay? And that the trial court is known as the court of original jurisdiction. They hear a case for the very first time. And so that when a person is charged by the state or the federal government with a crime, or it's the first time that a court is asked to settle a dispute, a civil dispute between individuals, that takes place in the trial court, okay? And we have trials for the criminal cases, but we also have trials to settle disputes over civil cases. A lot of civil cases settle outside of court. So do a lot of criminal cases too, because people take plea bargains. But both, you can have a civil and a criminal trial. So trial courts is the first court of original jurisdiction. It's the first court to hear the case. That they're both civil trial courts and criminal courts. And in the trial court is, that's kind of what you see on the TV, right? Not that what happens on TV is really like what goes on in a real courtroom. But it's in the trial courts that where evidence is presented, evidence that the state would present to prove beyond a reasonable doubt that somebody is guilty of a crime, evidence to support the claim that one of the two parties is the responsible party in a breach of contract, testimony. So evidence would be presented, witness testimony would be presented. There is sometimes a jury in a criminal case. There's usually a jury. You have that civil right, the civil liberty to have a jury trial, but you can waive that right, and you also have a right to a jury trial as well in civil matters. And then ultimately, the trial court renders a decision. It renders a verdict of guilt or not guilt in a criminal case. or it renders a decision regarding who the responsible party is in a civil case. So that's the trial courts. That's what they do. They conduct trials. So what does the appellate court do? Well, appellate courts are not courts of original jurisdiction. They do not hear the case for the first time. They hear cases on appeal. That's why it's called the appellate court. And so the main function of an appellate court is to basically review what takes place in the lower level trial courts, okay? And so if you are found guilty of a crime and that you have a right to appeal to the appellate court, basically you can say, I shouldn't have been found guilty because I had incompetent counsel. My lawyer didn't know what the heck they were doing. The jury was biased. The judge was a drunk, whatever. I mean, I'm just using exaggerated examples. Evidence was presented that was illegally collected. And so, that you're basically asking the appellate court to review the decision of the trial court. And that same review can take place for civil matters as well, that there was something about the way that trial was conducted that basically needs to be reviewed by judges. And so what happens in an appellate court is there's no trial, evidence isn't presented, but basically their function is to correct errors. There's no testimony. People don't come in usually and testify. But rather what happens is that lawyers for each side present briefs to a group of judges. Okay, there's not one judge. There's usually a group of judges, maybe 3 judges. It could be, the Supreme Court is an appellate court, 9 judges. Okay, and that basically attorneys for both sides present written briefs, not underwear, but written briefs to the judges. And the judges read through the briefs. And the one side, like in a criminal case, the state will say, this trial was conducted absolutely legally. There were no errors. Here's the argument in favor of that you should affirm the verdict, the verdict of guilt of the lower court. And the defense attorneys will submit briefs making an argument to the contrary, try to prove that no, in fact, errors were made. And then the judges read those briefs and then they make a decision. And it's majority rules. So if it's the Supreme Court, 5-4, majority rules. If it's 3 justices, 5 justices, the majority rules in appellate cases. And so what are Supreme Courts? Well, Supreme Courts are oftentimes known as the court of last resort. That everybody has a right to one appeal at the lower level appellate courts. But you don't have a right to appeal. You don't have to, the Supreme Court of the United States and no Supreme Courts at the state level, they don't have to hear your case on review. They have discretion and they could say, nope, we're going to let the decision of the lower appellate court stand. And so the Supreme Court are the highest court in the system. The Supreme Court of the United States is the highest court in the United States, but Wisconsin has a Supreme Court too. So when it's state matters, it's the Wisconsin Supreme Court that is going to make the final say about the constitutionality of a case as it relates to the Wisconsin state constitution. If it's about the United States Constitution, it will go to the Supreme Court. Okay, and Supreme Court, so it's just like a double check. It's the final sort of appeal that people can make to courts to see whether or not errors have been in fact been made. And so that brings us back to take a look at the graph again. On this side of the graph or diagram, it's not a graph, it's a diagram, that U.S. District courts are the trial courts. So if you're charged with a federal crime, you're going to be tried in a U.S. district court. And there are 94 U.S. district courts throughout the nation. Every state has one. The Wisconsin has 2, one in Madison and one in Milwaukee. If you don't like what happens, if you're found guilty at the federal trial level in the U.S. district courts, you can appeal your case to the U.S. Court of Appeals. And when you watch the Vox video, it'll show you that there are 11 circuit courts. And so while each state has its own trial federal court, we're clumped into circuits. That's why it's the U.S. Court of Appeals are in 11 circuits throughout the United States. Wisconsin is in the 7th Circuit. And if you want to appeal your case, you appeal to the court. It's in Chicago. Okay, it's in Illinois. And on the same side on this side. Now, keep in mind, every state has its own separate court system they organize their court system according to their own state laws, okay? So they all have trial courts and state appellate courts, and all states have state supreme courts, but how they're organized is different, okay? So just, know that we have that same reflection here. And then the court of last resort, the Supreme Court of the United States, which we're going to learn about in the next lecture. Okay, that's it for this lecture. On the next lecture, for lecture 2 for topic 8, we're going to be learning about the United States Supreme Court. I teach civil liberties. I encourage you to take that course if you want to learn more about the Supreme Court and about civil liberties. I teach that in the spring. It's one of my favorite courses to teach. But this will give you a little bit of a taste about how the power of the Supreme Court, how it's organized, and also its exercise of its main power, which is the power of judicial review. So we're going to learn about that in the next lecture, and make sure you take a look at the Vox video because it's a nice little summary about how a case gets to the Supreme Court. Talk to you again soon.